On today's On the Other Hand, we talk with someone who has worked to help Arkansans come together and to make our state better. Here's a sneak preview.
To characterize and stereotype judges really offends me. And I could say that generally across the board.
This is On the Other Hand. A podcast sponsored by Braver Angels in Arkansas, where hope and common ground meet.
Each episode features community leaders from Arkansas and beyond, sharing stories and insights on how we can strengthen our relationships and our communities together, and in doing so, discover what's possible. In the first part of our conversation with Annabelle Tuck, retired Arkansas Supreme Court Justice, she outlined for us some of her history as an individual and as an influential Arkansan. She also shared some of her perspectives with us, helping to demonstrate the potential for Arkansans to work together across political and other divides. Now, let's get to the second part of our conversation with Annabelle Tuck. So let me ask you this. I know that you at one point converted to Judaism during your adult life, and I was wondering how, that's kind of an example of where you have different perspectives that you deal with. How does your Jewish faith and that whole journey inform your worldview, and in particular, maybe your sense of justice?
Well, obviously, what is called the Old Testament, but I call the Torah as a Jew, it's real interesting. I was active as a Methodist. It wasn't that I was inactive, but I got real uncomfortable with certain of the theological beliefs. And I thought, God is one. Why do we separate into a Trinity and all that? Unfortunately, I had a wonderful minister, Dr. Jim Argue, at Pulaski Heights Methodist, who said, Annabelle, I think you need to read Abraham Joshua Heschel, one of the greatest modern Jewish philosophers. And I think you need to go see my friend, Rabbi Zeke Palahniuk, and take a course. But I'd already been exploring. I didn't just explore Judaism. I looked at other religions. And I came to understand that much of the law is based on the Torah. Contracts law, damages, tort law, all of those principles of fairness and justice come from the Torah, the Old Testament. If you read it closely, how does it was all about giving advice to a community on how to be a community and not be constantly fighting each other. Like, for example, Moses' father-in-law comes, to see him after they've crossed the Red Sea, and he sees his Moses just judging all day long, people waiting around forever, da 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 da. And he says, "You are doing wrong." And Moses probably said, "What do you mean?" He says, "You can't judge everything. You have to appoint magistrates to judge the less important matters. And then you're the appellate court for big matters." Guess what? Does that sound familiar? I found out that so much of the principles set forth in the first 5 books, Genesis, through Deuteronomy, really are part of our common law and have influenced our statutory framework.
That's fascinating. I didn't know that, and I appreciate you sharing that notion of how the Old Testament, the Torah, and that underlies a lot of our common laws. So I appreciate that. Another thing about your conversion to Judaism that I'm curious about arises from our dealing with people who have different ideas politically and other kinds of differences. And sometimes we don't expect people to change their mind, but sometimes they do. So I wondered, in your having gone through that conversion process to the Jewish faith, did it give you any kind of empathy or any kind of insight that would maybe apply to people who are making other kinds of changes or conversions in their identity?
Oh, sure. I had, I felt guilty about leaving my church because of the friendships and the support, but that didn't mean I didn't stay friends. In fact, I was invited to go over there and share my conversion experience in Sunday school classes. But I will say, I also learned what it was like to be in a minority. I mean, I knew. I mean, it was interesting. Phil Kaplan of blessed memory, who is a well-known lawyer in Arkansas and now deceased, he saw me one day and said, "I understand you're looking at converting to Judaism." And I said, "Yes, sir." And he said, "Are you really sure you want to take on that burden?" And you know what that means? And I said, "Yes, sir, I know." So I guess what I'm saying is the values were the same as had been in the Methodist Church, but the way, the pathway of connecting with the divine or connecting and relating to other people and the values I really felt had always been there for me. It wasn't like I was changing my value system at all. I had a lot of compassion for other converts. Okay. I had a lot of compassion for understanding that paths can be different. Doesn't mean I want to proselyte somebody else to be a Jew. No, absolutely not. I will not do that. That every pathway is a personal choice.
I wonder if it's possible that the conversion process and the exposure to the Jewish culture in any way changed your political outlook.
Now, I didn't convert as an Orthodox Jew. I converted under the Reform because I wasn't going to be a second-class citizen as a woman. I wanted to have full rights of, going up on the bema or the altar. I mean, I picked, and all religions have different ranges. Let's be clear about that. But I picked the Reform movement of Judaism, which started in Germany in the 18th, 19th century, for that reason.
Well, we're going to move now into some of your rulings that I guess you could say that they gained you some notoriety for in your time at the Arkansas Supreme Court. And I do think about, rulings that a Supreme Court justice makes or a Supreme Court at large makes all come from cases, right? And so there's background to these cases. So we're going to start with a significant ruling that affected public education in Arkansas. And this was actually a Lakeview school district issue. So give us a background on that situation.
Yeah. Well, that was filed, I think, it was assigned to me as a trial judge because I was not on the Supreme Court. And all constitutional questions have to be filed in Pulaski County because this is the center of government. It's the capital. And so it was filed in 92. And it was filed by the small school district, Lakeview. And it was basically saying that the state of Arkansas and its method of funding public education, by that I mean 1st through 12th grade, was unconstitutional under the Arkansas Constitution. Now, mind you, this was a provision that had been adopted back after the Civil War in the Arkansas Constitution. And I'll just read it to you because I think it's really interesting to read what was thought to be a public value at the time. Intelligence and virtue being the safeguard of liberty and the bulwark of a free and good government, the state shall ever maintain a general, suitable, and efficient system of free public schools, and shall adopt all suitable means to secure to the people the advantages and opportunities of education. So that provision, plus equal protection, which is also in the Arkansas Constitution, was being used, not the US Constitution, to argue that the funding of schools was unconstitutional because it was based solely on local property tax values. And if you know anything about Arkansas, you know that some areas, like in the Delta, where Lakeview was, their property is not that valuable. So their taxes are low. Their property taxes are low. Then you get into, central Arkansas or up in northwest Arkansas, and property tax values are much higher. And that would mean the education you got in Arkansas and the quality of the education and how much was spent for your children to go to school by the state was thousands of dollars of difference. So say Lakeview could only afford, and I'm just this is the range it was, $2,500 a year per student. In Northwest Arkansas, $7,500 a year per student. Now, I will tell you, my ruling in this case was not unexpected because there had been a case before that, the Alma versus Dupre, the Dupre versus Alma School District in 1983, 10 years before, where the Arkansas Supreme Court held that the financing system of public education bore no rational relationship to the needs of school children in every district. So it's not like I was looking at precedent. And candidly, the State Department of Education had all their lawyers there, and then the lawyer for the school district. And they gave me a lot of statistics, a lot of data. And the bottom line was we had to equalize the tax for education across the state at a higher level, property tax at a higher level, 25 mils for everybody. And that became a constitutional amendment. Now, I didn't do that. I just said, here's the problem. And then the state itself had to spread money fairly among the different school districts. Obviously, the legislature, when I said it's unconstitutional and I give you 2 years to fix it. Now, 2 years to fix it is a little stretch. I knew that it was going to be, I had to deal with practicality, which was, when does the legislature meet? When can the legislature do this? All that stuff. And so I will tell you that then I got my hand slapped by the Arkansas Supreme Court, which said, you can't do that. You can't give them 2 years. And I said, okay. Well, at that time, I was about ready to run for the Supreme Court. So Judge Collins Kilgore took the case, and he was the one who really should be noteworthy in taking it. And that eventually came up to the Arkansas Supreme Court, and I had to recuse.
Mm.
You're judging my work. Can't do that. And I used to get so tickled. Occasionally, one of the justices would say, "Can't you talk to me about this?" I said, "No." They thought I was just being too hoity-toity, whatever. But anyway, Judge Collins Kilgore took it, made the final opinions, and then it went up to the Arkansas Supreme Court. And then it had to go through several hearings because had the legislature in its legislation really fixed the problem. And it has to do with a funding formula and how you set a funding formula when you have special ed, when you know, as usual, the devil is in the details.
So that's impacted Arkansas. I'm assuming that funding formula is
Big.
still in operation now.
Well, it has to change. The funding formula they have to look at costs every other year when they're legislating on the budget, and then they have to go and refigure what it costs. I mean, inflation is here, and all that. And then they have to look at where schools are and what they're doing, how many special ed students, all that stuff. And so really it's a moving formula that has to be recalibrated every legislative cycle. And in fact, there's a statute that requires that.
A great case example for students of the law and political science as well, because it shows the interaction between legislation and the Supreme Court or courts. So I appreciate you sharing.
It was very unusual to have hearings post issuance of a mandate by the Arkansas Supreme Court to be sure that the decision was complied with. That was very unusual.
So that doesn't happen as often as we might think. Yeah.
Well, no, and the court can't tell them what to do. They have to do something, and then the court looks at it. Has it fixed the problem?
That makes sense. Well, you were also influential in legal status of LGBTQ plus issues, including marriage, during your time in the court system in Arkansas, I believe. So what would you like to tell us about what led up to that ruling?
Well, that was interesting. That case came before our court because Judge Bogart there had been a case filed by several professional people, had state licenses, that admitted they had violated the criminal sodomy statute because they were LGBTQ. And they were bringing it because they said, we could lose our licenses if we got convicted. Now, the prosecutor at the time was Larry Jegley, and and the AG argued on behalf of Larry that, nobody's been prosecuted, so you don't have standing. And that's always a baseline question. And so I must tell you that under the Arkansas Constitution, equal right, equal protection provision, the real debate in our court was, did these folks have standing? Did we have jurisdiction? That's what was so interesting. And I had to go back to a case where a teacher had taught evolution, and it was a crime to do that. I mean, this was back in the 50s, whatever. And an Arkansas opinion. And the Supreme Court said, that this is sufficient interest in the outcome of the case for us to have jurisdiction and to take it up. And candidly, if you read that opinion, the vast majority of my opinion was about that issue, because the two dissenters, that's what their position was. The real issue of equal protection and violating the Arkansas Constitution's provision on equal protection and privacy, everybody agreed on. So I'm just sharing that with you.
I want to ask one clarification issue, because you just mentioned it had to do with the sodomy statute. And for the listeners who may not be real sure what that's about, because this is not about gay marriage or anything, that predates that.
No.
Just briefly explain what that law was that caused people such concern.
Okay. It made any what I would call homosexual behavior a crime. And so other states had that too. And, you know, it obviously there's some cultural factors in that kind of statute. But in this case, it was about the state action may affect my ability to be a school teacher, to be a social worker, my having a status of being homosexual, that status itself, and me having a partner will basically mean that I'm subject to losing my job. So it obviously, I understand there are different religious perspectives on this. I'm not arguing about that. I'm just saying in terms of state involvement, government, and how are you going to prosecute that? As Prosecutor Larry Jegley said, we've never prosecuted that. How are you going to prove that? Go into somebody's bedroom and film them? And this was about adults only, not children. This was about consenting adults. And that was very critical to it. So I hope I've explained that.
Yeah. You know, as a Supreme Court justice, I don't know how much you have to actually work across the divide, but I'm assuming there were a lot of players that were working across the divide leading up to that decision. And I'd be interested to know if you saw any of that happening and what was going on behind the scenes.
Well, you know, it's like anything. I mean, there's a lot of things in the newspapers, a lot of op-ed pieces and all that. But to be honest with you, I never read any of that stuff. I said, I've got my plate full with the cases I'm dealing with, and I'm not going to spend my time reading the public media about it. Now, we would get amicus briefs from different organizations, but they're just amici. They're amici. We read them, but they're not the parties in the case. And they do make political arguments. But my concern was more about the Arkansas Constitution and what it says about the right to privacy and equal protection and your status, your personal status, and how you are treated based upon your personal status. So, yeah, it's all there. But I'll tell you, our colleagues, the colleagues on the bench at that time, this was not about politics. I could tell you everybody has a different way. Each of us, you could say on one topic or one issue was conservative or liberal, but then you go to another topic and be totally different. to characterize and stereotype judges really offends me.
Mm-hmm.
And I could say that generally across the board.
Yeah. I mean, I think, we've politicized the courts.
Right.
And I do, and used it as a weapon or a tool, depending on who's in office, especially at the national level that you see that. I am curious about, and I think you've talked about this, but there is some concern that some think that the courts actually are legislating from the bench. You probably have heard that criticism.
Sure.
And for you, the Constitution was so important. Case precedence was so important.
Yeah.
You looked at you've talked about the equal protection, who has standing. How do you address the concern that some people think that these types of rulings are actually attempts to legislate from the bench?
Well, we could get into jurisprudential debates, different philosophies on how to interpret statutes, how to interpret the Constitution. There is a whole litany of doctrines that have come, over the course of hundreds of years about how to interpret a statute. And language, as you know, sometimes can be interpreted in different ways. And so I'm not going to sit here and say to you, I'm just using the original meaning. I don't know what the original meaning was, because under Arkansas law, we don't go and like you do in the federal system, look at the CRF, the things that the Congress publishes about what their intentions were. We only can look at the language. And candidly, sometimes the drafting is a little less than perfect, and we can't rewrite it. So, I will come out and tell you that as for constitutional interpretations, I believe the framers had, first of all, the Arkansas Constitution is over 40,000 words. It's all about what you cannot do to me as a government. The Constitution of the United States is much more compact and principle-driven. And it hasn't been amended as many times as the Arkansas Constitution has. It's very difficult to amend. So I'm just sharing with you, there are two different constitutional frameworks, and I'm, as a judge, and I would interpret the U.S. Constitution if they were claims at the same time. Now, they could appeal to the U.S. Supreme Court on that. But I'm just sharing with you that I do not believe in original intent construction, as Justice Scalia put on the table, because otherwise our Constitution is dead. It's a dead document. It can't deal with new things like the internet. It can't deal with computers and all of these new issues that come up. And so it has to be a living document. Now, if you think that's legislating, I can't change your mind. But the document has separation of powers, has checks and balances, and to go back and say, I know exactly what the founders thought they were doing, I think that's Monday morning quarterbacking.
That's fascinating that you're talking about that. I've heard a lot of that, and we could get into a whole long harangue about that, but we're not going to. But I will say this: it reminds me of something I heard about the original intent argument at the federal level, saying, well, if you go by that strictly, the intent for the Second Amendment only involved muskets, single loaders, so you couldn't involve anything else. Yeah.
I mean, let me tell you, as the old saying goes, it depends on whose ox is getting gored.
Yeah. Yeah. Okay. All right. Thank you. Well, let's move on then. I'm aware this question, as I originally had it, I want to kind of change it a little bit because you've mentioned you don't like being stereotyped. You've already told us you're actually rather conservative in many ways. But I will say this, that at least the popular conception or perception for years has been that you are a liberal. It is certainly true that you're a woman, and both of those are things that have not always been held in high esteem in Arkansas. So for some of our young listeners, they may be really surprised to think that, you mean that many years ago, you as a liberal woman got on the Supreme Court? How'd that happen? So answer that however you want.
Well, I think I was just coming of age, so to speak, and coming into the public sphere at a particular time. And it wasn't me, it was women. And like I said, I was the second partner at Wright, Lindsay, and Jennings. It was a time when doors were opening for women. And I just happened to be at that door opening time here in Arkansas. Now, I'm not saying I didn't fight for it. I did. And that was because I felt just as competent and just as able to do the job as any man. And I will tell you just a little story. When you campaign, people come up and ask you that question. So what makes you think you're better than the opponent? First of all, I had no opponent, so they couldn't do that. But I was up at Mount Nebo with the chicken fry. And I was going around handing out my cards and asking for votes. And this elderly man, about my age now, came up to me, and he had his overalls on. He looked just like my grandpa. And he said, "Young woman, I'm not going to vote for you." And I said, lawyers know not to ask the question, why? But I just said, why? What is it that's making you, because I thought it'd be because I'm a woman, because you're just too young. And I looked at him, and my reply was, you see all this white hair? I earned it legitimately.
That's great.
And he laughed. I have no idea who he voted for. But the point is, I couldn't have a chip on my shoulder all the time. I had to use some humor to because here I was expecting, you're just a woman. That may have been the real reason, but that wasn't what he was going to say. So I'm just sharing with you, it was just a happenstance of the time.
And who knows, maybe you changed his opinion.
I can't tell you why I was unopposed the rest of the times I ran.
I didn't realize it. Did you ever have an opponent for any of your judgeship positions?
My first position, Van Smith and I were opponents. And he had the political connections, all this stuff, and I had none. And I worked it as hard, and he worked it hard. It was a very cordial push. It was really both of us out there. I think we saw each other more than we saw our families. And after I won, I had lunch with Van, and I said, Van, you need to run again. And he did. And he became a trial judge too.
Cool.
And he eventually was president of the Arkansas Judicial Council. So, I mean, it was, a lot of it is name recognition.
Well, what I really like about that is hearing the civility, the mutual respect that you had back then, and we need more of that now. But I want to move on to something else here. You've earned the right to comment on the judicial system at the state level, certainly, and I think at the national level, and that, as April alluded to earlier, is something that's going on a lot of discussion about that. So give us maybe a few key observations that you have about the role of the Supreme Court, both at the state level in Arkansas and U.S., about the role of courts today, the challenges they're facing, what changes are needed, that sort of thing. What do you think?
Well, I can say as an opening statement, I feel like many of the doctrines, the rule of law, precedent, doesn't seem to hold water right now. So I feel like I'm in a different world. I never felt, when I handed down the Lakeview decision, I thought, okay, I'm going to get an opponent the next time. That's the way it works. But I didn't. I have no idea why, but I'm just telling you, it's not about an agenda. It's about dealing with each case, thinking through what the law has been, whether it's constitutional, what the consequences will be.
We hope you enjoyed this second part of today's conversation with Annabelle Tuck, and that Annabelle's story gave you a little more hope and a reminder that we can do good things together.
If you liked what you heard, share the episode with a friend and help us spread stories of bridge building across Arkansas. And remember that On the Other Hand offers dozens of other interviews like this one. You can find our On the Other Hand podcast inside your favorite podcast app or on the podcast page of the Braver Angels Arkansas website at arkansas.braverangels.org.
Music was composed by Randall Standridge of Jonesboro, Arkansas, and was performed by the University of Northern Colorado Symphonic Band, Dr. Richard Main Conductor. I'm your host, Glen White.
And April Chatham Carpenter.
Join us in working to make our relationships and communities better.